Britney Spears is actively challenging the conservatorship that has dominated every aspect of her life since 2008, but why? Well, reportedly the conservator, that is the guy in charge of her life, was making $10,000 a week while she was only given an allowance of $2,000. She was forced to get an IUD so that she couldn't have another child, and she was appointed a lawyer who never told her that she could challenge the conservatorship, and that is just the tip of the iceberg.
I shouldn't be in a conservatorship if I can work and provide money and work for myself and pay other people.
Britney testified in a probate hearing for the first time in over a decade, and she tells a story about being forced to perform against her will.
He handed me a sheet of paper as I got off the stage in Vegas and said I had to sign it. It was very threatening and scary, and with the conservatorship, I couldn't even get my own attorney, so out of fear, I went ahead and I did the tour.
And despite the conservatorship during the preparations for this tour, she took responsibility for rehearsing and directing her own dancers.
I wasn't good. I was great. I led a room of 16 new dancers in rehearsals. It's funny to hear my manager's side of the story. They all said I wasn't participating in rehearsals and I never agreed to take my medication. Ma'am, I'm not here to be anyone's slave. I can say no to a dance move.
She also said her conservatorship, which has mostly been directed by her father, Jamie Spears, refuses to allow her to marry and have children.
I want to be able to get married and have a baby. I was told right now in the conservatorship, I'm not able to get married or have a baby. I have a ID inside of myself right now, so I don't get pregnant. I wanted to take the ID out so I could start trying to have another baby, but this so-called team won't let me go to the doctor to take it out because they don't want me to have children.
The things Britney said about her conservatorship are harrowing and include allegations of abuse. And there are, of course, circumstances when a court-appointed conservator is given the right to assume responsibility for someone else's life decisions, and that makes sense. Although Britney's conservatorship was originally based on her own mental health crisis, one would assume it takes more than that to maintain a legal conservatorship for more than a decade over a seemingly functional adult. But we don't have to look very hard to find people who have repeatedly filed for bankruptcy, or have had very public mental health crises, or have had a serious drug habit and caused their life to spiral out of control, and even those who are being manipulated and conned out of their money. But none of these people have been subjected to a conservatorship, the kind that Britney Spears has been under for a decade. So what does it take for a court to put a person under a general conservatorship? And why does Britney Spears want to end this conservatorship in her case? Well, today I'm going to tell you everything you need to know about what is happening to Britney Spears. Hey Legaleagles, it's time to think like a guardian ad litem because Britney Spears has been under a conservatorship for over a decade. So what is a conservatorship? Well, a conservatorship is a court-appointed arrangement in which a person or organization is chosen to protect and manage the finances and at times the personal care of someone whom a judge has found to be unable to manage their own affairs. A conservator is responsible for using their judgment to arrange for the care and protection of the person under the conservatorship. The person under the conservatorship is known as the conservatee. Now, there are a few different kinds of conservatorships under California law. Britney Spears has been under a general conservatorship since 2008. This is governed by the California Probate Court. There are conservatorships of adults who cannot handle their finances, personal care, or both. This consists of two parts: conservatorships of the estate and conservatorships of a person. A conservator of the estate is appointed to administer the person's financial life, such as investing the person's money, protecting their assets, paying their bills, and budgeting for expenses. A conservator of the person takes charge of the person's non-financial life. Now, the specifics differ depending on each person's circumstances, but generally a conservator can decide where the person will live, whether they receive an allowance, and whether they can make their own personal care and health decisions. General conservatorships have no termination date. They can and usually do last until the end of the person's life. But at the same time, the vast majority of these conservatorships involve the elderly or the infirm, people that manifestly cannot take care of themselves. So it's not something that lasts 50 years, it might be something that lasts 5 years until they pass away. But let's talk about the scope of conservatorships, because once a conservatorship is established, the limitations on a conservatee's freedom are incredibly broad. As disability rights lawyer Patricia Cavey points out, quote, "In many ways, the deprivation of liberty through an involuntary guardianship order is greater than that suffered by a convicted felon. Prisoners retain basic rights to control medical decisions, bodily integrity, and the right to conduct their business affairs and retain their estate. Wards do not." The due process protections of the 14th Amendment apply to guardianships and conservatorships, but due process only guarantees the right to notice and a court hearing. The Supreme Court has never decided a case establishing the precise parameters of due process in the context of guardianships or conservatorship. This means that there is no universal requirement that people who are subject to conservatorship proceedings have specific rights, like a Sixth Amendment right to an attorney. Most states require or allow the appointment of a lawyer, but they don't necessarily let the conservatee choose their own lawyer. Once a conservatorship is established, the costs of administering the person's life are paid by the conservatee, the person who is under the care of these other people. This doesn't automatically mean that there's a conflict of interest, but it's something that Britney flagged when she spoke in court. The fact that her family lives off of her fortune and her performances provide a living for many people creates a conflict of interest.
It's been a long time since I've owned my money, and it's my wish and my dream for all of this to end without being tested. Again, it makes no sense whatsoever for the state of California to sit back and literally watch me with their own two eyes make a living for so many people and pay so many people trucks and buses on tour on the road with me and be told I'm not good enough, but I'm great at what I do.
So that brings us to the very obvious question of who is able to initiate a conservatorship over another adult? Well, any person who wants to be a conservator can file a petition for conservatorship. This could be a spouse, a relative, a friend, or even a manager. And under the law, the court gives preference to certain people: a spouse, adult children, parent, sibling, or another person. And in Spears' case, her father, Jamie Spears, filed a petition for temporary conservatorship in 2008. This was later converted to a general conservatorship, and he sought and received the right to manage the estate and her person. Attorney Andrew Wallet was later named co-conservator. And now, why was Britney's father appointed as a conservator? Well, because she was not married at the time, there was no one else higher on the priority list. And it's possible for the same person to become conservator of both the estate and the person. To be appointed as both, separate petitions have to be filed. So what is the legal standard to force another adult person into a conservatorship? Well, California Probate Code Section 1821 requires the initial petition to show the following. Number one, the inability of the proposed conservatee to properly provide for his or her needs for physical health, food, clothing, and shelter. Two, the location of the proposed conservatee's residence and the ability of the proposed conservatee to live in the residence while under conservatorship. Three, alternatives to conservatorship considered by the petitioner or proposed conservator and reasons why those alternatives are not available. Number four, health and social services provided to the proposed conservatee during the year preceding the filing of the petition. And number five, the inability of the proposed conservatee to substantially manage his or her own financial resources or to resist fraud or undue influence. This is, and frankly should be, a very high bar for the petitioner to clear. The facts need to show that the person is not capable of taking care of themselves or of managing their own finances, or that they are susceptible to manipulation. Now, in the case of Britney Spears, we don't know exactly what the facts were that the court relied on when it determined that Britney needed a conservatorship back in 2008. When Jamie Spears petitioned the probate court, Britney had been through enormous upheaval in a very short period of time. Britney was harassed repeatedly by the paparazzi. She publicly shaved her head shortly after the death of a beloved aunt. And this event was captured by cameras and became an enormous tabloid story. She was also in a divorce and in a custody battle with Kevin Federline. She had voluntarily gone to rehab and done 2 stints in a psychiatric institution. We assume that she has a disability, but we don't know whether she has any psychiatric diagnosis. Now, Jamie Spears also told the court that Britney's new manager, Sam Lufty, was abusing her, and the court in these proceedings entered a restraining order against Lufty. Now, while we don't have all of this information, I don't think anyone seriously questioned the necessity of the Spears conservatorship at the time. However, in retrospect, it's fair to ask whether the Spears family could have used a less restrictive measure to protect Britney, or whether this conservatorship has gone on for way too long. Now, what are some less restrictive measures that could have been instituted? Well, for starters, a power of attorney, where a person legally authorizes an individual to make financial decisions for them. This could be a spouse, a friend, a manager, or even a lawyer. A person might also agree to give temporary custody to their children to their ex. Giving someone power of attorney allows them to make decisions on your behalf, but it doesn't allow them to control your every waking moment. There can be mediations in court-ordered rehab when drugs are an issue, and someone who has power of attorney can create a trust and pay the bills of their client and put them on an an allowance. All of these are serious steps, but they don't compare to the severity of a conservatorship. But of course, sometimes conservatorship is necessary. Now, you might ask, aren't there some legal safeguards to make sure that the conservatorship is necessary on a continual basis? Well, there are supposed to be safeguards in these arrangements. The conservator has to periodically report to the court about the status of the situation. In some circumstances, the conservator will need court's approval to make certain decisions. And in the beginning of this process, a court-appointed investigator is responsible for interviewing the potential conservatee, explaining their rights, and making recommendations to the judge. However, after the conservatorship is established, the investigator only speaks to the conservatee every 2 years. And here, Jamie Spears maintained full control over Britney even after Sam Lufty was gone, her divorce and custody arrangements were final, and her drug use had apparently ended. Public reports show that Jamie, quote, had the authority to restrict and limit her visitors, oversee her personal security, and dictate her medical and psychiatric treatment. Jamie has repeatedly said that he only wants what's in her best interests and that he loves his daughter and wouldn't force her to do anything that she wouldn't want to do. But of course, the Free Britney movement has pointed out cracks in this facade for years. When Britney had a successful run of shows in Las Vegas, people started to question why a highly skilled performer was still under a conservatorship. Then things started to unravel publicly in 2019. In January, Jamie's original co-conservator Andrew Wallet resigned after asking for a raise. That left Jamie Spears as the sole conservator of both Spears' person and estate. The New York Times recently reviewed a transcript of a hearing from the spring of 2019 when Britney's lawyer, quote, asserted that she had been forced into mental health facilities against her will on exaggerated grounds, which she viewed as punishment for standing up for herself and making an objection during a rehearsal. At the time, Britney's lawyer filed a document saying that Britney was afraid of her father. And later in 2019, Kevin Federline backed up this claim. He helped their teen sons file for a restraining order against Jamie because of something he did to one of their children when they visited with Jamie. And Federline's attorney said, quote, Britney exercised appropriate parental conduct, removing her children from a dangerous situation. This order was granted without opposition from Jamie and barred him from contact with the boys for 3 years. In September of 2019, Jamie Spears asked to be released from managing Britney's personal care. The court appointed Jody Montgomery a professional conservator. Jamie continues in his role as manager of the estate, and he has told the court that he opposes ending his conservatorship. The court allowed Jamie to take a 1.5% cut of everything Britney makes from her performances. This is in addition to his monthly salary of $16,000 for acting as conservator and doesn't include Jamie's attorney's fees, which are also paid out of Britney's estate. Britney said, quote, they've done a good job at exploiting my life, talking about her father and Montgomery in June of 2021 when she addressed the court for the first time. So what about the lawyer? Well, Britney has a court-appointed lawyer, Samuel D. Ingram III. Under California Probate Code Section 1470 and 1471, judges are required to appoint counsel for the proposed conservatee in some situations. Most court clerks have a rotating list of lawyers who serve as court-appointed counsel. Now, in practice, this means that the person isn't picking their own lawyer. Now, how can this be? Well, the basis for conservatorship is literally that the person isn't competent to enter into contracts. So Jamie Spears has repeatedly emphasized his belief that his daughter is not capable of handling her own business without being taken advantage of by other people. And since this is the very foundation of the conservatorship, a judge can also presume that the person isn't competent to hire their own lawyer. And Ingram told the court in 2020 that Britney wanted her father replaced by Bessemer Trust as co-conservator. The Bessemer Trust is a bank. Now, Ingram told the court that Britney was actually afraid of her father and that in the future he might file a petition to end the conservatorship. But despite Britney's apparent discomfort with the conservatorship, Ingram never filed a petition to end it. And according to news reports, Ingram told the court that Britney wanted a chance to speak, but he had no idea what she would say. During the court hearing, Britney said that he never told her she had a right to file a petition to end the conservatorship.
I was told I have to sit down and be evaluated again if I want to end the conservatorship. Ma'am, I didn't know I could petition the conservatorship to end it. I'm sorry for my ignorance, but I honestly didn't know that. I don't feel like I should even be in a room with anyone to offend me by trying to question my capacity of intelligence, whether I need to be in this stupid conservatorship or not.
If this is true, this could be a serious ethical lapse, because just because the lawyer is appointed doesn't mean that they don't have all of the same ethical obligations to any client, to zealously represent that client to the best of their abilities and in the best interests of their client. And there are other holes in the record regarding Ingram as well. Probate law allows the court to set the lawyer's fee and to bill it to the conservatee's estate. And Ingram right now is making $10,000 a week in fees as her lawyer, yet neither he nor the court could produce the order which established his rate or allowed him to bill that much. It's possible that he was making $10,000 a week since 2008. All the while, there are reports that Britney was given an allowance of only $2,000 a week. All the while, her estate is worth north of $60 million. However, at the same time, Britney says she also has developed a good relationship with Ingram.
Actually, I know I've had grown with a personal relationship with Sam, my lawyer. I've been talking to him like 3 times a week now. We've kind of built a relationship, but I haven't really had the opportunity by my own self to actually handpick my own lawyer by myself. And I would like to be able to do that.
It's theoretically possible based on the size of the estate that these fees are warranted. It's possible based on the amount of work that he is doing that these fees are warranted. But we just don't happen to know. The situation with Ingram just isn't clear. But it certainly seems suspicious on its face. And what we're witnessing here may be true confusion by Britney and Ingram about the lawyer's role. The nature of the conservatorship can often blur the ethical lines between advocate and guardian. California law requires lawyers to maintain confidentiality and loyalty to their clients, and there's no exception for lawyers appointed to represent conservatees. And in fact, California rejected a proposed rule of professional conduct, which would have given lawyers some freedom to give their own opinion about their clients with diminished capacity. For example, San Diego lawyers Ann Rudolph and Ralph Hughes argued that the nature of conservatorship encourages lawyers to actually report on their clients to the court, explaining what they feel is in the best interest of their client, rather than advocating for what their clients actually want. They say that this violates the lawyer's ethical duty to keep attorney-client communications confidential. And in their view, this violates the lawyer's ethical duty to zealously advocate for their client. A lawyer, quote, cannot tell the court what the client has said without the client's consent, cannot ignore the client's stated desires and goals, and cannot advocate something that the client does not want. So for example, this could lead a lawyer to using the best interest standard to make decisions about the client's mental capacity, decisions that arguably the lawyer isn't qualified to make. And in other words, a court-appointed lawyer should be an advocate for what the client wants, not act as a guardian ad litem who substitutes their own judgment for the client's wishes. And it's also important to recognize that despite the "we're here to help" attitude, conservatorships are inherently adversarial. They strip people of their most fundamental rights. Now, most lawyers would say that the nature of this process requires lawyers to be zealous advocates, but in California, there are court decisions allowing lawyers to exercise their independent judgment on crucial matters impacting their conservatee, including whether to withdraw life support. In cases permitting lawyers to decide to pull the plug, an appeals court has emphasized that there isn't a law requiring a court to get involved in a conservator's decision to literally withdraw life support. This raises another question: does the court get involved when other fundamental rights are at stake, like reproduction? Well, we sort of have an example in the case of Britney Spears, because choosing whether and when to have children is a fundamental constitutional right that includes the right of procreation, sterilization, and abortion. Yet coerced sterilization in the US has a long and horrible legal history. In 1927, Oliver Wendell Holmes, one of the most respected jurists of all time, wrote one of the most shocking Supreme Court opinions ever in Buck versus Bell, which upheld Virginia's Eugenical Sterilization Act. This law allowed the state to forcibly sterilize Carrie Buck, a poor woman that the state had said should not be able to have children. The opinion is infamous because Holmes wrote, "3 generations of imbeciles is enough." Carrie Buck actually didn't have any discernible disability, but her foster family initiated a court proceeding against her after their nephew sexually assaulted her. The case is a lesson on how easy it could be to convince a court to take away a person's freedom. It's also a lesson in even respected jurists on the Supreme Court get things horribly, horribly wrong. And after Buck versus Bell, America sterilized about 70,000 people. And in this case, Britney told the court,
I wanted to take the ID out so I could start trying to have another baby, but this so-called team won't let me go to the doctor to take it out because they don't want me to have children.
This means that at some point she got an IUD that prevents pregnancy, but when she decided that she'd like to have another child, her conservatorship, run by her father, refused to allow her to see a doctor about taking it out. We don't know whether there was ever a hearing regarding Britney's IUD, but the rules of conservatorship do not expressly require one, even though it obviously impacts a fundamental right. Just as no California statute or decision purports to require judicial approval of a conservator's decision to forego further medical treatment, there's no statute requiring judicial approval of a conservator's decision to limit a conservative's reproductive choices. The conservatorship is broad and powerful. Since medical decisions are part of the conservatorship of the person, Britney has no final say over her own medical treatment, including whether she uses birth control. And this court has delegated power to conservators, so it takes a hands-off role unless there is a petition to terminate the conservatorship. So let's talk about whether it's possible to end a conservatorship and whether it should be ended. One of the reasons that the Spears conservatorship started to get attention was because Britney's activities seemed to undermine Jamie's assertions that she needed it in the first place. And let's just look at what Britney has done over the last 13 years. She's released 4 albums, served as a judge on a reality show, and performed hundreds of shows during a Las Vegas residency. Judging by her work, Britney is in a very different place than she was in 2008. Why is a woman who is not yet 40 with a full-time and very demanding job who shares custody of 2 children still under a conservatorship? Remember, this isn't about being bad with money or using drugs or refusing to go to therapy or anything else that a lot of other Americans may struggle with. For the conservatorship to be necessary, the person must still be unable to manage their affairs full stop. The legal standard remains that a person is unable to provide for their basic needs like food, clothing, shelter, and be incapable of making medical decisions. For financial decisions, the requirement is a person being unable to manage their financial affairs or resist undue influence. But here's the problem. The burden isn't on the conservator to establish the continuing need for conservatorship. The burden is instead on the conservatee to prove that they don't need it. And although it may seem pretty simple to make this showing, I'm not sure how easy it is. Now, if you aren't capable of cooking for yourself and want to avoid getting put in a conservatorship, you've got to try HelloFresh. Oh God, that's so mean. Now, I have to say, I was initially pretty skeptical about HelloFresh. I'm a pretty good cook, so I didn't think that I needed the help, but I actually loved it. Even for an experienced cook, HelloFresh provides new ingredients and recipes that I would never have tried on my own. Everything I've gotten has been insanely delicious, easy to cook, and actually really healthy. And most recently, I made yogurt marinated chicken with garlic sauce and steakhouse pork chops. Both were incredibly delicious and not something I would normally make on my own. If you feel like you've been cooking the same thing every day in quarantine, HelloFresh is a great solution. And of course, everything was delivered straight to my door, so I didn't have to do any shopping. The produce actually gets to you faster than in a grocery store, so it arrives at peak freshness and flavor. And it's also super easy and saves time. HelloFresh cuts out meal planning and prep, so the recipes take only 20 to 30 minutes to cook. Literally less time to cook than it would normally take to do the shopping. And it's also really sustainable. Since the ingredients are pre-portioned, there's less prep and less wasted food. The packaging is almost entirely made from recyclable or already recycled content. And HelloFresh's carbon footprint is actually 25% lower than meals that you would make from store-bought groceries. So if you want to try HelloFresh, go to HelloFresh.com and use the code Legaleagle14 to get 14 free meals. Yeah, 14 free meals plus free shipping. So again, for 14 free meals, go to HelloFresh.com and use the code Legaleagle14 or click on the link in the description. Plus, clicking on that link really helps out this channel. So, do you agree with my analysis about the whole Britney situation? Leave your objections in the comments and check out this playlist over here with all of my other videos about the legal issues in the news. So click on this playlist or I'll see you in court.